So, having looked at this, we wonder, is there any way to perhaps maybe put something definitive on the fair use defense? In Princeton University Press, the versus Michigan documents, the court effectively acknowledged that applying the fair use defense is somewhat difficult and nebulous. In fact, the court stated, fair use is one of the most unsettled areas of the law. The doctrine has said to be so flexible as virtually to defy definition. Wow, what does that mean? It kind of brings to mind a famous quotation of Justice Stewart in a 1964 Supreme Court case in which Justice Stewart was called upon to address the issue of obscenity. The issue was, it wasn't a copyright case, it was one in which the Supreme Court was addressing the issue of whether the movie was obscene or protected by First Amendment freedom of speech. And they had to define obscenity. And Justice Stewart says, I know it when I see it. So how do we define fair use? Do we apply the I know it when I see it test? That seems to be rather vague and ambiguous. In fact, particularly in view of the fact that there's been some rather substantial litigation involving the use of software and of materials, it's my understanding that you've been addressed by some people who have referred to the most ubiquitous, ubiquitous search engine. I don't even have to say it. It's Google. Google has established a program to copy the libraries of Harvard, Michigan, Stanford, and the New York Public Library. It's an awful lot of copying. They're digitizing it. And they intend to make snippets available to users of Google. One wonders, well, what is the ultimate implication of this? This project began several years ago, and perhaps understandably, publishers were sort of like, well, they felt like upset, or maybe it was that they just wanted a piece of the action. There was a letter that was sent by the Association of American University Presses, dated May 20, 2005, to Google. I copied the entire text as one of the appendices. It's an awful lot of information. It's written in tiny print, not necessarily the most exciting thing, but there are a few interesting issues that are made. The idea that the AAUP states, the idea that once this gigantic digitization project has been completed, anyone with a computer and internet access will be able to use Google and search the collections of these libraries is enormously seductive. Okay. However, it also appears to be built on a fundamental violation of the Copyright Act. Well, they say it's a violation. This large-scale infringement has the potential for serious financial damage to the members of AAUP. Well, he hasn't identified the financial damages. He hasn't really identified where is the detraction from the revenue stream. He did state, however, that Google's claim that it's fair use to make copies of every copyrighted work in even one major library, let alone 3, is completely unprecedented. Well, I would agree with that. I think a fair use case like this is, I haven't seen any precedent for that. Courts have never recognized a fair use claim of that magnitude. Well, that's true also. I don't think that they recognize a claim of that magnitude. That doesn't necessarily mean fair use doesn't apply. Well, interesting, Microsoft has weighed in on this. Microsoft has a program where it seeks alliances from copyright owners with, who scan books. Microsoft, which is also at loggerheads with Google, took issue. Recently, there was a speech delivered by the Associate Counsel of Microsoft, Mr. Tom Rubin. I sent him an email, asked him if I could get a copy of the entire speech, and he sent it to me. I think I may have included it as one of the appendices. He states that Google's chosen path would no doubt allow it to make more books searchable online more quickly and more cheaply than others. And in the short term, this will benefit Google and its users. Well, that sounds reasonable. But the question is, at what long-term cost? In my view, Google has chosen the wrong path for the longer term. because it systematically violates copyrights and deprives authors and publishers of an important avenue of monetizing their work. That means publishers aren't getting some more money. In doing so, it undermines critical incentives to create. Okay, I'm so pleased to see that Microsoft, which would never use its Goliath economic power to infringe someone's intellectual property, is coming on the side of the publishers. Okay, recently, I assume that you've heard of some of the litigation involving Google. Sometimes I think that half of what Google does is provide internet search services, and the other half is litigating copyright infringement cases. Excuse me. Google was involved in a case in which it was sued by Viacom. Google has recently acquired YouTube. Seemed like it made news. It was $1.6 billion. Seems like a lot of money until over the weekend I see that Google is now buying DoubleClick for $3.1 billion. So, you know, in retrospect, the YouTube deal wasn't all that big a deal, only 1.6. Well, apparently Google has acquired YouTube, and for those of you who use YouTube, you know that you can upload some video on YouTube. I think that they upload maybe, I think it's a max of about 100 megabytes or about 5 to 10 minutes. According to YouTube, they've stated that most videos on YouTube are under 5 minutes long, and there is a 10-minute length for all videos. Okay, well, sometimes the video might be just like a video of a party. Some folks are getting together, or a family gathering. They upload it, and someone sends it to some people who couldn't make it. Or, gee, we all had a great time at this function. It's a home video. Sometimes it could be a video of some copyrighted material. And so Viacom seems to be rather upset that some of the copyrighted material is copyrighted material that is owned by Viacom. So Viacom filed a lawsuit in federal court in New York, in the Southern District of New York, and it alleged copyright infringement. The case was a complaint in federal court.